to Session 3 of the online human rights training. In this session, you will learn about confidentiality. Confidentiality. Each individual is entitled to have all identifying information that a provider maintains remain confidential. Each individual has the right to give his or her authorization before the provider shares identifying information about him or his care. Authorization is updated annually and as needed in writing. Employees and sponsors must confirm there's an authorization on record before sharing information. Remember that all aspects of the person's life are confidential. As an employee, you may share information with other employees and anyone else who has authorization. Authorizations are kept in the individual's permanent file. Before disclosing information with anyone other than a coworker, contact your site coordinator, the individual's QIDP, or leadership on call before you share the information. Don't assume that just because the person who's trying to get information is the individual's mother, that they have authorization to receive that just because they're mom. That may not be the case. You still have to verify that there's an authorization on record. Never ever leave the individual's medbooks or site books open and laying around on desktops or tables. Be sure computers and Therap are closed down when not in use. The individuals must also give us written consent to use pictures and videos for media purposes. So be careful what you put on your social media sites. Do not post pictures or videos of the individual you support on your own personal sites, such as Facebook. Also, you are not permitted to keep pictures of the individual you support on your personal cell phone. Of course, this does not apply in the same way to family members of the individual who are supporting them in a sponsored setting. Providers are obligated to tell each individual and his authorized representative about individuals' confidentiality rights. This shall include how information can be disclosed and how others might get information about the individual without authorization. If a disclosure is not required by law, providers shall give strong consideration to any objection by individuals or authorized representatives. Providers shall prevent authorization disclosure of information from service records and shall maintain and disclose information in a secure manner. As explained earlier, your responsibility is to close all site books and computers when not in use, and to store site books in their correct location. Do not leave individual documentation lying around, and make sure it's kept secure. Also, do not disclose information with non-SSVA employees until you first verify that there is a release. When providers disclose identifying information, they must attach a statement that informs the person receiving the information that it must not be disclosed to anyone unless the individual authorizes the disclosure, or unless state law or regulations allow or requires further disclosure without authorization. If for some reason you must send an email to an outside entity, verify that there's a release and then create a disclosure at the end of the email indicating that the information being received must not be disclosed to anyone unless the individual authorizes the disclosure or unless state law or regulations allow or requires further disclosure without authorization. This typically applies mostly to QIDPs, sponsors, or managers, and not to the DSP, because as a DSP, you would have a supervisor send out this information instead of doing it yourself. In some limited circumstances listed in the regulations, providers may disclose certain identifying information without authorization or violation of the individual's confidentiality. The following regulations discuss these limited circumstances. Once we review the regulations, I will explain how this applies to you as a DSP or a sponsor. The provider may disclose identifying information without authorization for the following limited circumstances. Emergencies. The provider may disclose information in an emergency to any person who needs that particular information for the purpose of preventing injury to or death of an individual or other person. The provider shall not disclose any information that is not needed for this specific purpose. This regulation does not include disclosing information for the purpose of preventing substantial property damage. Providers or health plans. Providers may permit any full or part-time employee, consultant, agent, or contractor of the provider to use identifying information or disclose to another provider for a health plan, to the department, or to a CSB any information required to give services to the individual or to get payment for services. Court proceedings. If the individual or someone acting for him introduces any aspect of the mental condition or services as an issue before a court, administrative agency, or a medical malpractice review panel, the provider may disclose any information relevant to that issue. The provider may also disclose any records if they are properly subpoenaed and if the court orders them to be produced, or if involuntary admission or certification is being proposed. Legal counsel. Providers may disclose information to their own legal counsel or to anyone working on behalf of the legal counsel in providing representation to the provider. State providers may disclose to the OAG or anyone appointed by or working on its behalf for representation purposes. The Human Rights Committee. Providers may disclose to the LHRC and the SHRC any information necessary for the conduct of their responsibilities under these regulations. Other authorized or required by the Commissioner, CSB, or private program director. Providers may disclose information to other persons if authorized or required by one of the above for the following activities: licensing, human rights, or certification of accreditation review hearings, reviews, appeals, or investigations under these regulations. Evaluation of provider performance and individual outcomes, statistical reporting, pre-authorization, utilization reviews, financial and related administrative service reviews and audits, similar oversights and review activities. Pre-admission screening, services, and discharge planning. Providers may disclose to the department, the CSB, or to other providers information necessary to screen the individual for admission, to prepare and carry out a comprehensive individualized service plan, or a discharge plan. Protection and Advocacy Agency. Providers may disclose information to the P&A in accordance with that agency's legal authority under federal and state law. Protection of the public safety. If an individual receiving services makes a specific threat to cause serious bodily injury or death to an identified or readily identifiable person, and the provider reasonably believes the individual has the intent and ability to carry out the threat immediately or imminently, providers may disclose facts necessary to alleviate potential threats. We call this duty to warn. Inspector General. Providers may disclose to the Inspector General any individual service records and other information relevant to the provider's delivery of services. Physical therapy notes. Providers shall obtain an individual's authorization for any disclosure of psychotherapy notes, except when disclosure is made for the provider's own training program in which students, trainees, or practitioners in mental health are being taught under supervision to practice or improve their skills in a group, joint, family, or individual counseling. To defend the provider or its employees or staff against any accusations of wrongful conduct. To law enforcement officials, pertinent to search warrants or grand jury subpoenas, in response to their request for the purpose of identifying or locating a suspect, fugitive, or individual required to register as a sex offender, and Crimes Against Minor Registry Act, material witnesses, or missing persons. Other statutes or regulations. Providers may disclose information to the extent required or permitted by any other state law or regulation. How this applies to you as a DSP or sponsor. It is not the expectation that you remember all of these regulations pertaining to confidentiality. It is, however, expected that you understand that the individuals have a right to confidentiality, and we need to protect that to the best of our ability. It is best practices when it comes to confidentiality to share information with other employees, supervisors, or contracted workers of SSVA. However, when doing so, do not share embarrassing information about the individual in front of them. Be mindful of what you say, and be sure you are sharing information to assist the individual in getting a good life, not just for gossiping purposes. Be careful when you're telling stories about the work you do here at SSVA. It's okay to tell stories, but be careful not to share the person's name or other identifying information with people who are not authorized to have that information. Do not share any information with a family member or outside entity prior to ensuring that there is an authorization on file first. If you are unsure, do not share the information and refer the person to the individual service coordinator or to your supervisor. Remember duty to warn. You should share any needed information with police or EMS workers. When sharing information with the general public, remember, duty to warn protects you from sharing unauthorized information with that person, as long as you feel that they are in imminent danger of physical harm or they are in a life-threatening situation. In duty to warn situations, you should complete a GER and notify your supervisor, leadership on call, or the internal human rights advocate directly as soon as possible. Congratulations, you have finished Session 3 of the online human rights training. Now proceed back to Moodle to take your quiz.